Okay. Good afternoon, everyone. My name is John Hurley. I'm your judge this morning. This afternoon, remember you have the constitutional right to remain silent, but if you give up that right, whatever you say can and will be used against you. Also, if you have a private attorney, let me know who that is. We'll contact your attorney and let them know that you're in court. May I see William Fisher, please? William L. Fisher.
Well, it's not until...
Present.
Hi, Mr. Fisher. We're here on 15-0086-59 CF10. Sir, your counsel has filed a motion for disqualification of this court. The court's had time to review that. At this time, the motion to recuse the court is hereby denied. The court signed a written order. We'll proceed with the hearing. State,
Judge, before we proceed, can the court state for the record the reason for denial of the judge? As far as I know, the only issue is whether it's a legally sufficient motion. I believe it is legally sufficient. Can the court state for the record, for the appeal purposes, the reason for denying the motion?
No, the court would not be allowed to state for the record. The court is not allowed to state for the record either denying a motion or granting a motion for disqualification. The court can only state one or the other, and then after that, you have appellate remedies, but the court cannot get into the reasons on. It's only a written denial or granted. So,
may I ask if the court finds the motion to be legally sufficient?
the court will deny the motion at this time. Thank you. Now, may I ask, State, does this defendant have any criminal record? I need the paperwork.
You gave him nothing.
Okay. Your Honor,
Your bond is $1,000. Can you afford it? You have $1,000 downstairs to bond out. I get the paperwork on.
1 moment. Okay. 2011, possession of marijuana. In 2009, he was arrested for trespass and domestic violence battery. He was found not guilty. For the record, Your Honor, I've also provided a copy of the sworn petition from the victim's mother, I believe the victim's mother. Your Honor, I would note for the record, it does make allegations that Mr. Fisher has abused her daughter in the past. I would note for the record, this petition contains an affidavit.
To be clear, the court's already found probable cause.
Yes.
You're showing this petition to the court post probable cause.
Yes, Your Honor, that's why after the priors.
I take a look at the petition too.
Yes, absolutely.
Let me just look at it real quick. The respondent continually came to my residence 3 to 4 o'clock in the morning, banging on my door. Police were called repeatedly. Respondent left prior to police arrival. Respondent came to my residence again, 5 a.m. and something about my daughter's new car, keyed my daughter's new car. Respondent physically abused my daughter and cursed me. Respondent has verbally, physically assaulted my daughter during their relationship. And I'm residing in my home, will come out uninvited. And I look here on the last page. This is sworn to by Letta Daniels. It's in a affidavit form, April 1st, 2015, and it's a petition for injunction for protection against stalking. Letta Daniels, the petitioner, William L. Fisher Jr., this defendant, is the respondent. And
Judge,
I just read that brief paragraph.
Judge, my only concern with that, with the state admitting that and the court taking that into consideration, is that it hasn't been authenticated for evidentiary purposes.
Right.
We don't know. There's no certification. It's not authenticated. It's third-party hearsay. It hasn't been authenticated by the state. There's no business record that's for the court to take judicial notice of. I mean, it's not certified by the clerk of courts, and I would just, my objection, again, files Obzo with the Law Office of the Public Defender on behalf of Mr. Fisher. I would voice my objection based on that.
I understand. The court notes your objection. The court is looking at this document as a public record. It's public record. I've got a case number at the top, 15-002454. The heading on it is the Circuit Court, 17th Judicial Circuit in and for Broward County. And it is a form document, Florida Supreme Court approved family law form 12.980, Paragraph T, petition for injunction. This is a public business it's a public document kept in the, I believe it's kept on the clerk's website. Am I correct?
Well, it is, Your Honor, and that's where I got it from. Additionally, Your Honor, as far as the argument that it's hearsay, every single report the court is asked to consider for probable cause is hearsay.
Right.
So I believe that legally speaking, the court is allowed to consider this. I believe under the rules of criminal procedure, it is relevant, and the law is clear that the court may consider. There's several factors that states the court can consider, and there's a catch-all at the end that says anything the court finds relevant, and I do believe this is relevant.
It is hearsay, but the court is we are post probable cause, and we've been post probable cause for quite a while now. The court just is considering this not as probable cause, as petition. The court's just considering what's in it, trying to figure out where to set the man's bond and how to set his release conditions, and the court's just going to give it its, the court's going to give it its rightful due. I'm not sure we're going to give it how much weight we're going to give it. I'm not sure. It's kind of hearsay, over a hearsay. But that being said, State, Mr. Miller, aside from the legal issues, do you have a issue regarding bond or release conditions at this time?
Judge, Mr. Fisher runs his family's lawn business. He's been doing that for about 6 months. He lives with his mother. He has no money in the bank, no money to post bond with. He's requesting pretrial release if possible. Other than that, Judge, we would just ask the court not to consider this extrinsic information that's provided by the state as more prejudicial than probative.
Well, there are a lot of things that are more I think it's it's whether the risk of unfair. I can't. I'm going to. It's after lunch, and I had a big lunch. But that being said, the court has reviewed the document. I don't give it a lot of weight. I'm not going to totally ignore it. I don't want to set a precedent that the court would ignore documents such as this. But in this case, this document is not that compelling factually to the court. The court just really actually relies more on the underlying probable cause affidavit. But because in any event, this petition is not. It's not brought out by the alleged. It's not taken out by the alleged victim in this case. It's allegedly taken out by the victim's mother. So, okay. So that being said, does the defendant have the ability to post bond at this time, Miller? Mr. Miller?
No, Judge, he has no money of his own.
Okay, got it. And I'm not sure that it meets the proper level for probable cause regarding her pregnancy. However, let me ask, was there contact with the alleged victim on this?
Yeah, she's not in fear for her safety.
She's not in fear? Okay, sir.
No contact order.
She does want to know contact. So the court's going to set your bond today at $5,000 based on the facts of the case, level of violence, your criminal record. The court will order you have no contact with Lita Daniels. Do not call her, text her, email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're out on release. Now, the court will enter the motion for disqualification into the record.
Judge, there's also
The petition for injunction for protection against stalking, which is the document that is at issue that the court looked at. That goes into part of the court file, and you've got my order, right?
Judge,
Okay.
I just got a printout,
Your Honor?
of order of dismissal of temporary injunction, which says the reason it was dismissed is that the petitioner failed to appear at the hearing scheduled in this cause on April 14, 2015. The case was called at 10:25 a.m. and it was signed by Judge Bailey. May I just give this to Patrice and maybe the court can...
Your Honor?
Stop. Let me just look. Okay, is that the same case number? I don't know.
I don't know, I just...
No. The one you have is 152454, correct, Judge?
Correct.
No, it has not been dismissed. She has sought to obtain injunctions against him previously.
Wait,
Wait, which one do you have?
152452.
That's the one you have in front of you, or that's the one showing dismissal?
That is one I have in my hand. That was given
That's
to me
showing
by-
dismissal. That's the daughter who sought an injunction. The mother's is still in place.
So the one I looked at that's at issue in this case
Is
is
fif-
the one that's still in place.
Yes, 152454.
But in any event, whether it's still in place or not, I think that's kind of missing the point. The point is the court was considering it for the alleged facts it contained, whether or not it's still in effect. It looks like it's not in effect against him because this is somebody else. But even if it were or wasn't, I'm looking at it for the facts it contained.
Your Honor.
But, okay,
Sorry.
now that being said, we're
Well,
going to move
well,
on.
wait, Your Honor, if I could just have one, if we could put this on the brief recall, it's really more of a PC issue than necessarily a bond issue. I just literally got something, literally just now from Lauderhill on this case.
Judge,
That there's,
I'm sorry.
What is it?
Judge has already made a ruling. Okay, now the state is asking the court to reopen the case. We're objecting to the court to the state reopening the case. If they want to reopen the case, let them file a motion and have it heard and done properly.
Yes,
Okay,
sir.
this is just.
Yes, sir. Have a seat, sir. We'll be right back with you. Thank you. Okay, now, you can put that case to the side. Thank you. Now, okay, I'm going to call up Jeremy Backus, please.
Anthony Bruno on behalf of Jeremy Backus.
State your name, sir.
Anthony Bruno?
Okay. Fine, Mr. Backus. Where's Mr. Is he going to be in here?
I don't think he's going to be in there, Judge.
Okay. Go ahead.
Your Honor, we're here because the state and defense have agreed to place the defendant on a level 1 pretrial release with a $7,500 bond with special conditions of his release that he does not drive, he doesn't consume alcoholic beverages, random alcohol testing, no contact with the victim's family, and that the defendant may not apply for a new passport. He's already surrendered his passport. The state just wants to make sure he doesn't get a new one.
Okay, let me ask you this. Is he, how would he be held responsible for these conditions? How do we know that he would know about these conditions?
Your Honor, this has been discussed with defense counsel who spoke to Mr. Backus.
Okay,
This was all agreed upon,
right.
and we were initially going to have a surrender hearing today, somewhere along the line, somehow, because Miss Abdi still has the original warrant for his arrest. Somewhere along the lines, a warrant was filed, and he got picked up once he got home from our office when we were initially going to do that surrender hearing today. And these were the conditions that he was going to surrender
I
to.
understand.
And Your Honor, pretrial could always advise him of these conditions as well.
Is he in booking?
He's in booking, he hasn't been booked yet.
Is it possible they can bring him from booking to the courtroom and send him back to booking when we're done?
Before he's booked in for charges. He's not booked. He hasn't been fingerprinted.
No, I know. But can they just walk him over here so I can talk to him real quick? Okay.
While you're looking, I'm just wanting to read the court order. I can't write an order if he's not booked, and I don't have charges to put on there.
Understand. Just give us a moment here.
It has to be right now, Your Honor.
They bringing him? Okay, may take a couple of minutes, all right?
Sure. Thank you, Judge.
Okay, now, may I help you in the front row?
Thank you, Your Honor. Eric Rutenberg on behalf of Robin Lopez, standing in for Felipe Jaramillo, attorney of record. Sure.
Okay, may I see Robin Lopez, please?
President Domain and approaching judge.
Okay. Mr. Lopez? Sir, do you speak English?
No.
No English?
No English.
Okay, we'll call up the interpreter, all right?
Thank you, Your Honor.
Thank you.
Siéntate. Gracias.
There. Okay. Mr. Shade, are you expecting,
I haven't heard from any of them, Judge. I know Mr. Lanius isn't going to be coming.
would you call City of Fort Lauderdale? Thank you. We're working on that. Thanks. Okay. Steve?
I'm just putting out one last thing, Judge.
Okay, what about Jessica Swerdloff?
I can't.
President Domain, judge.
He's been arrested twice for DV battery against her. One was an ag bat.
Photo order, please, Mr. Officer.
What's in it?
Swerdloff, you're charged with
Figure.
domestic battery, ma'am. The court finds probable cause. Steve, do we have any priors on Ms. Swerdloff?
He moved out 5 months ago. He doesn't have a key. He went in through a window.
1 second, Your Honor.
Wasn't his fault.
Does he own it? Does he have a lease? I mean, those are the pertinent factors.
She's married to someone else now.
Yeah.
You got a possession of cannabis and resisting without violence, 2012.
I need to point a guardian on this case. All right, Ms. Swerdloff, it says, was, I believe here, extremely intoxicated. She used a knife to slash the tire of the couple's vehicle to prevent a man named Prudhoe, Richard Prudhoe, from leaving. Due to Swerdloff's extremely intoxicated state, combative attitude, Prudhoe took the 7-month-old child away from her to take her to another residence. So, take the child away. Swerdloff threw a punch with her right hand and hit Prudhoe in the face. So, ma'am, I'm gonna, well, go ahead. Do you have anything you want to say on behalf of Ms. Swerdloff, sir?
Judge, first I would like the court to take note of Ms. Swerdloff's injuries that she received as a result of this incident. She's a 6-year resident of South Florida. 8 months is her current location. She's currently unemployed. She stays home to take care of her 7-month-old child. Strong family ties, no money or real estate. She does have a place to stay, separate and apart from the alleged victim in the case, and she will be asking her brother to help bond her out when she gets a phone call, which apparently she has not yet received.
I understand. Ma'am, you have a 7-month-old child, and at 3:46 in the morning, you're extremely intoxicated in the town of Davie to the point the father of the child has to remove the child from you. So, I do know you have a prior marijuana, prior resisting arrest. The court's going to set your bond at $3,500, ma'am. But the court will order that you have no direct contact with Richard Prudhoe. You can have indirect contact with him regarding the child, but you're not to have any direct contact. Don't call him on the telephone, don't text him, don't email him. You must stay 500 feet from him at all times. That's where he lives, works, goes to school. You're not allowed to possess any guns, any weapons, any firearms while you're on release. I'm going to order you're not allowed to consume any alcoholic beverages while you're out on release. Ma'am, the court also has appointed a guardian ad litem for the child, and the court will ask, will you please contact the Department of Children and Families? Ma'am, I have a duty to make sure DCF is contacted regarding your behavior around the child. And thank you.
Yeah.
3,500.
Yeah, what's up?
Lawrence. This was Lawrence in the LAU.
Okay, now,
Always shades. He can't be like Larry, he has to be like Laurie. Laurie.
oh boy.
We can go back to Fisher if you want to, Judge.
Quick moment here.
We have Backus in the courtroom.
Okay, just give me a quick moment. Okay. Backus. Okay. Mr. Jeremy Backus.
Hey, Jim.
Hello, Mr. Backus. Sir, we have your attorney in court. Say your name.
Anthony Bruno.
Okay, and
Patricia Abdi on behalf of the state.
okay, and sir, there has been an agreement between the prosecutor and your attorney on your release conditions. I want to make sure you're aware of what they are. Now, the bond will be $7,500, correct? And there's a passport surrender requirement. Is that correct?
He's already surrendered his passport. The state is asking that he not go and request a new one.
Now, do you have the order I could look
Yes.
at so I can tell him what those conditions are? Thank you. Okay, let's see here. Sir, bond 7,500, special conditions. You're not allowed to operate a motor vehicle under any circumstance. Is that clear?
Yes, sir.
Okay. You are not allowed to consume any alcoholic beverages while you're on release. Do you understand that?
Yes, sir.
Okay. You're going to have to submit to random alcohol testing. You're not allowed to have any contact with the victim's family. And you are not allowed to have a passport in your possession. You're not to apply or seek to have a passport. Do you understand that?
Yes, sir.
And that's your passport or anyone else's passport. Is that clear?
Yes, sir.
Okay. Is there a restriction about him leaving the county or the Tri-County area?
Your Honor, he's allowed to travel in the Tri-County area.
Okay. Sir, I'm going to allow you to travel within the Tri-County area. Miami-Dade, Broward, West Palm. But you're not allowed to leave the Tri-County area. You're not allowed to go onto an airport property. You're not allowed to board an aircraft. You're not allowed to go into a port facility. You're not allowed to board a boat or an ocean-going vessel. Is that clear?
Yes, sir.
You're also not allowed to have a ticket or any contract for passage on any ship, boat, or aircraft. Is that understood?
Yes, sir.
Okay, anything else?
Your Honor, I'm not sure if you said that he's not allowed to have any contact with
Yeah.
the family of the victim.
I read it right out of the...
Okay.
Judge, and just that he is on level 1 pretrial release as of right now.
Okay. It doesn't... Yeah, it is. Right here. I see it. Level 1. Okay. Thank you. Is that it? Anything else?
That's it.
That's it, Your Honor. Thank you.
Okay.
Thank you, Judge.
This needs to be dated. There you go.
Do I have a seat?
They have to stand, yeah. Oh, we have a Spanish interpreter.
If you want to just stay with William Fisher real quick, it'll just take a few seconds.
Oh, no.
And this is really more of a PC issue, Your Honor.
Hold on. Let me back up.
I don't know, I think,
Yeah.
come on, Mr. Fisher. Let's do this.
Okay, so... Hold on. Just give me a moment here. I'm getting inundated with paperwork here. Okay, so we're back. What else did you need to say, Steve?
There's a second set of reports, offense incident report, Your Honor, that I provided. And if you go to the second page,
Okay.
starting with the second paragraph, Daniel stated,
Right.
I believe the court will find that there's sufficient evidence that Mr. Fisher was aware of Ms. Daniels' pregnancy.
Okay, let me look here. We're involved in a 1-year romantic relationship and she's currently 3 months pregnant with his child. Fisher is aware that she's pregnant carrying his child, according to Daniels. She further stated that Fisher has attended several doctor's appointments. Okay, so I'm going to find probable cause for aggravated battery on a pregnant female. All right, now that's it. So we're.
Thank you, Judge.
That's a wrap. Thank you. We're going to move on.
Okay, off you go. Good luck.
Now,
You're done now.
the bond remains the same. Got it? Okay, now, okay, ma'am, come on up. I got a lot of paper moving here quickly. Do you swear or affirm to translate from English to Spanish, Spanish to English truthfully?
I
To the
do.
best of your ability.
I do.
Okay, hold
Mr.
on.
Lopez is approaching,
Just give me a
Judge.
moment. Okay. Now,
There's
who do we have?
This is Robin Levano?
So Robin Lopez.
Robin Lopez.
Lopez, sorry.
Okay.
Yeah, it's 24 hours to perfect the PC. I'd argue that the state has not perfected. All they've come up with is circumstantial reasons that don't amount to PC. For the fact example that.
Just interrupt real quick.
Sure.
Good afternoon, Mr. Lopez.
Buenas tardes, señor López.
Sir, you're here on 2 counts of burglary with a battery.
Está a 2 cargos de allanamiento con una agresión.
We have an attorney here in court for you.
Tenemos aquí un abogado presente para usted.
Could you state your name?
Eric Rudenberg.
Mr.
Es
Rudenberg.
Eric Rudenberg.
You don't need to say anything, Mr. Lopez.
No necesita decir nada, señor López.
Let your attorney speak on your behalf.
Deje que su abogado hable a su nombre.
You understand that?
¿Entiende eso?
So go ahead.
Thank you, Your Honor. Just by way of brief background, the parties, the defendant and the alleged victim in the case
El
were
acusado
previously
y la
married.
parte estaban previamente casados.
It seems that this was at one time the marital home,
Parece ser que esta era una casa, un tiempo en la casa matrimonial,
and now the parties are divorced.
y ahora las partes están divorciadas.
The victim, the alleged victim, is remarried,
La alegada víctima está casada de nuevo,
but nowhere in the probable cause affidavit
pero en ninguna parte en el affidavit de motivo justificado
is it alleged
se alega
what the relationship between the
cuál
defendant and
era
the
la
property is.
relación entre el acusado y la propiedad.
For example, whether he's still on the lease,
Por ejemplo, si todavía está en el contrato de arrendamiento,
who owns the property,
quién es el dueño de la propiedad,
now that the divorce is finalized,
que ahora que el divorcio es finalizado,
the sort of circumstantial evidence
el tipo de evidencia circunstancial
the state relies upon
que el Estado se respalda
is the manner of entry,
es la manera de entrada,
the fact that the defendant didn't possess a key to the
el
residence,
hecho de que el acusado tenía una llave a la residencia
and the fact that the alleged victim is now remarried.
y el hecho de que la alegada víctima está casada de nuevo.
None of this amounts to a showing
Nada de esto demuestra
that this is a property that the defendant could possibly burglarize,
que esta es una propiedad que el acusado puede posiblemente allanar,
because taking the 4 corners of the probable cause affidavit,
porque tomando el fundamento de la affidavit de motivo justificado,
it's not even alleged that it's not the defendant's property.
no se alega de que no es la propiedad del acusado.
And he, I think, admittedly did have a right of possession, undoubtedly,
Él
at one point.
admitiblemente, él tenía posesión de esto.
How do you say that he undoubtedly had a
¿Cómo
right
dice
to
que él sin
possession?
duda tenía posesión?
He used to live there. This was his listed address. In fact, on the PC affidavit, it's still listed as his address.
El affidavit de motivo justificado lo demuestra como su dirección.
He now has a new address, but it's not clear what his relationship to the subject property is at this point.
Pero no es clara cuál es la relación a la propiedad.
Facts you're allegedly telling you're telling the court here are they're kind of leaps in faith that because it says on
Una
the
de las
report that he
cosas
had
que
that
dice en el
address that he used to live
reporte
there. I
que
don't know,
él
maybe he got his
tenía
mail
la
there.
dirección ahí,
Maybe
quizás
he never
recibía su
lived there.
correo ahí,
He
quizás
just
nunca
told his
vivió ahí.
wife, "Can I
Y
use
solamente
the
estaba
mailbox?"
su esposa,
Maybe he
puede
never
usar
had
el
a right
correo.
to go to the door of the
Quizás no
mailbox.
tenía el derecho de ir
I mean, I don't know
al,
that.
I would agree with her, but I think that sort of puts it backwards. The state doesn't allege that he has no right to be there in the probable cause
El
affidavit.
Estado no alega que él no tenía el derecho de estar ahí en el affidavit de motivo justificado.
That's why you came back. You got way too
Not,
close.
you don't have anyone testifying to these things.
No tengo a
I
nadie
understand, Your
testificando
Honor.
esto.
But the only
entiendo su
allegation in the probable
señoría.
cause affidavit that would even give rise
Pero el
to
único
an allegation of burglary is
alegado
that
allanamiento
the alleged victim didn't want him.
es que
It
la
doesn't say that
alegada
it's not his
víctima
house.
no
It
lo
didn't
quería
say that
ahí.
he has a restraining order. It
No se
doesn't say
dice que
anything else
tiene
that
una
would
orden de alejamiento
suffice
ni
to
que
prove
no era
or to
su
show
casa
probable cause or allege probable cause
para
that he
alegado
didn't have a legal right to be there. And the
justificado.
burden's on the state to show that or
No
allege that.
tenía el derecho de estar ahí, el Estado tiene la responsabilidad de demostrar esto.
Just to take the devil's advocate side of this, why, if he were allowed to be there,
Para
would he have
hacer
to
el
force
lado
open
opuesto,
the
¿por
children's
qué
bedroom window
va a tener la ventana del
late in the
niño
evening to get in the
abierta?
home?
I'm not disputing, Your Honor,
Yo no
that
estoy
he may have not had a key. As the
disputando
police
que
court
quizás él no
states, he
tenga
didn't
una
have a key
llave
to the residence, but that's
a
not
la
sufficient for it to be
residencia,
a
pero eso
burglary.
no es
Why would
suficiente
he
para
knock
hacer
on the front door?
allanamiento.
Your Honor, I've never spoken to him about it, and I understand
Yo
your
nunca le he
point,
hablado
but
de
I think
eso
it
a él,
requires assuming something that's
pero
outside of the four
requiere
corners of the PC
asumir
affidavit
Why
to
would you
el
transmute
respaldo
that
del
into a
affidavit de
burglary.
Why
motivo
wouldn't he just knock on
justificado.
the window and have his children go to the front door and open it for
¿Por
him?
qué no hace tocar la
I
ventana y
don't
que
know,
los
Your
niños
Honor.
le abren
Maybe
la
you didn't want to wake
puerta?
them. I'm just, I mean,
Quizás no
I'm
quería
answering in the,
despertarlo.
the abstract. I don't know
Yo
the answer to
estoy
that question.
contestando
But the probable cause
abstracto.
affidavit should say this
Yo
was
no
not his
sé las
home, he had no right
contestas
to
a la
be there, and it would have been a
pregunta.
trespass otherwise.
Hubiera sido una intrusión
This
si
is
no
proper
era.
perspective. You,
Bajo
it's your
perspectiva,
position
es su
that
posición
the wife, the
que
former wife,
la
is
ex
married to another
esposa está
man.
casada con otro hombre,
But this defendant
pero este
pries
acusado
open a bedroom window,
abre la
gets in the
ventana de
house
un
when they're
dormitorio
already in
y
bed,
se entra a la casa
and allegedly
que
attacks
alegadamente ataca
the new husband,
al nuevo esposo,
but he's got a perfect right to be in the house.
pero él tiene derecho
But
perfecto
it's my
de estar
position,
en
Your
la
Honor, just to be
casa.
clear, that if the state put in the probable cause affidavit either that it was not his house, just
Si el Estado
alleged he had
puso
no
en el
right to be
affidavit
there,
de
then
motivo
it wouldn't be
justificado, alegó que no
an
tenía el
appropriate
derecho de
topic for
estar
discussion,
ahí,
but they don't say that.
sería la
They just say that he
decisión
didn't have a key.
correcta, pero no tenía la llave, es lo que decía.
Your Honor, the state will be seeking a foreclosed bond.
El Estado pide una fianza.
Judge McHugh's issue, as has been told to me by the Assistant State Attorney Gina
La
Messina,
Fiscalía Jim
was
Messino
the reports listed the same address for both.
reporte que dice la misma dirección para dos,
I believe that issue has not only been corrected, but there is proof evident of presumption grade.
pero que hay gran prueba.
First, Deputy Sherlock does list
La agente
an
Sherlock
address, a current address for Mr.
anuncia
Lopez
una,
on Davie Boulevard.
En Davie Boulevard una dirección para el señor López.
Yes.
¿Cuándo fue que
Your
esa
Honor?
dirección llegó su dirección del momento?
I don't know, but if it
Su
became his
señoría,
address
no
even a
sé,
day
pero
before,
si
then
fue
this
su
is not his
dirección un
address.
día antes de, entonces esta no es su dirección.
He's in contact.
¿Qué pasa después que sea en
You know, we're
contacto?
gonna send it out to my mom's
Va a
house.
mandarlo a mi casa de mi mamá.
Your Honor, what that would require then
Señoría, ese requiere
is that he set up an entirely new
que él ponga
address
una dirección nueva
in less than 24 hours.
en menos de 24 horas.
No,
¿Qué pasa con la dirección de su hermano?
well then here's the thing, if this is his address, once again to raise your issues, if this is where he lives,
Si este es donde él vive,
with his ex-wife and her new
su
husband,
esposo y su nuevo
where he doesn't have a
esposo,
key,
donde
and where
él no
she
tiene
is
una llave,
specifically
y
told
donde
the
ella
police,
específicamente le dijo a la
doesn't
policía,
live here.
él no vive aquí.
He is not.
Say that.
¿Dónde dice eso?
Robin does, and this is the second to last paragraph on
El
the
segundo
second page.
párrafo en la segunda página.
Robin does not have any keys to the
Robin
residence,
no
nor
tiene
is he
llave a
allowed
la
entry into the
residencia,
residence
ni se le
at any
permite
given
entrar a la
time
residencia en
without
ningún
Vilma's
momento
permission.
sin el permiso del dueño.
Ilma and Robin concurred in the fact that Robin moved out of the house approximately
Estoy de
5 months
acuerdo que
ago.
hace 5 meses Robin se mudó de la casa.
Well, even if he were an owner of the house.
Aunque sea dueño de la
Even
casa.
if he owned the house. Sir, let me ask you this.
Señor, déjeme hacerle esta pregunta.
You could own a property but
Usted
still have
puede
no
ser
rights, not have rights
dueño
to
de
own
una
the property.
propiedad y no ser de tener derecho de ser estar en el sitio. Si yo arriendo ese departamento en un edificio, aunque yo soy el terrateniente, si yo rompo una ventana y voy y ataco al inquilino, eso todavía sería un allanamiento con agresión, aunque yo soy dueño. Porque hablando de la ley de la propiedad, ser dueño es cuando tiene legal título y adquirido, porque no tendría para él tener derecho a la propiedad. Eso es lo único que me recuerdo del derecho de propiedad. Pero creo que estoy correcto. Él no tiene título de equitativo para entrar ahí.
I would agree that's an example I was thinking of myself, but the problem is the state doesn't allege any of that. All the state alleges is that the person who is the alleged victim in this case said that she doesn't approve of him being there. They don't say he's not on the lease. They don't say that he's not an owner. The PC just doesn't say that. The state could have procured in 24 hours sufficient evidence to show that the title's not in his name, or that he's not on the lease, or that he was ousted from the property to go back to property law. They just don't do that.
Ni que puede estar en la propiedad.
We're going to wrap this up.
Vamos a terminar esto.
If a homeowner gets burglarized, a home invasion at 12
Si un dueño de la casa se allana, están en la cama a las 12 de la madrugada
comes through,
y un extraño viene
attacks them while they're in
y
bed,
lo ataca mientras que está en la cama,
the homeowner says, look,
no es suficiente que ese dueño de casa diga que ese hombre no se permite tener en la casa, o tenemos que sacar el título de la casa para ver quién está en el título de propiedad.
If the probable cause evidence said he had no legal right to be there, I wouldn't be making these arguments. That's it, Judge. That's the only thing. It doesn't even say he had no legal right to be there.
No decía que no tenía derecho legal de estar ahí.
show me that he has a legal right
¿Qué
to be
tiene usted
Your Honor,
para
respectfully, I think that shifts the burden. I don't have to show anything. The state would have to prove probable cause.
El Estado tiene que probar motivo justificado.
You're pulling out a
Usted está sacando.
I'm just saying, Judge, that the state doesn't allege he had no right to be there. That's it. If you look at and you read the probable cause, they don't say that. And he used to live there. It was his address as listed at some point. So there's clearly a connection to it. And he was married to this woman at some point in the past, according to the PC affidavit.
the court today will find proof
El
evidence
juez va a
presumption
llamar
grade
que hay prueba alta para un allanamiento y una agresión, el cargo número 1 y
I do
2.
respect the defense's
Yo respeto
position,
la
but the
posición
court
de la
believes there's
defensa,
enough here to
pero
sustain
el
that
juez
highest
cree que
level
no
of
hay
proof.
ese nivel de prueba más alta.
Defendant will be held
El acusado va a ser detenido
without bond
sin fianza
for further order of the court.
hasta que haya una orden
Defendant
judicial
will
que lo
have to
cambie.
seek some type of relief through an Arthur hearing.
El
Right, sir?
acusado tiene
Thank you,
que
Your Honor.
hallar prueba por una vista de Arthur.
I have one more.
Okay, let's hope it's not as
Nuanced.
draining as that last one, sir.
It's,
Gracias, sir. Thank you. You'll be held without
Gracias,
bond.
señor. Va a ser detenido sin fianza.
Oh, I didn't mean to be flippant about it.
I'm just,
Okay.
I have Louis Diamani.
Here we go. Okay, now, Louis Damiani. Sir, you
Yes,
have
sir.
an attorney here representing you?
Yes, Josh Rydell.
Yes, sir. I'm sitting in for Joshua Rydell on this matter.
I think this is fleeing and eluding. No driver's license. Telltale revealed he has no driver's license. The individual's not got it. Currently out on bond for burglary, drive with no driver's license. Did you know he's out on a burglary right now? Okay. What's the case number on that?
1416016 CF10A.
CF10?
Yes, Judge.
Okay. And I'm just going to go ahead and set bonds. And sir, I'm going to go ahead and just revoke his bond on the case he's out on.
I would just want to state, Your Honor, he has health issues, and the offenses in this case, the alleged new violation and the one that he was out on bond for, totally unrelated, different type of offense.
Well, he's out for driving without a driver's license, I believe.
Oh,
is
is I think that's a new offense.
Well, there's two cases. I mean, there's a burglary and grand theft felony, and the second case is a possession of marijuana and no valid DL. Do you want that one also, or do you just want the felony?
You know, I'm going to revoke both. Do you want him to get credit for time served on the misdemeanor also?
At this point, I decline to resolve that one, Your Honor. I just
No,
want
but
to.
I'm saying if I don't revoke it, he's going to not
Oh,
get
I understand.
credit.
Right.
You wanna give me that?
1515883 MM10A.
Okay, so
Your Honor, we would ask that that bond remain intact. I don't know that it's going to be a jail sentence anyway, and I wouldn't want that to be the thing that, if he is able to resolve other cases, holds him in for a matter of days or weeks.
Excuse me? Is this sure if I can speak?
I'm
Is
going
it
to go
okay
ahead
if I
and
can
set
speak?
the defendant's bond, $1,500 on count 1, count 4, no, I'm sorry, count 3. That bond will be $2,000. His total bond on the new cases will be $3,500. Basically, the defendant keeps driving with no driver's license, and this time fleeing and eluding the police allegedly. Court will revoke your bond on 1416016 CF10 and 1415883 MM10. You're going to be held without bond. Thank you, sir.
Thank you, Your Honor.
Yes, sir. Okay, we're going to. Okay. Jakari Vereen, Lawrence Fisher, Bruce Paul, Sean Falconer.
Judge, I have one for Hollywood. Can I go that one first?
Lawrence Fisher, no problem, John.
Okay. What about Jakari? Where's Jakari?
Right here, sir.
You can hear me?
Yes, he can hear you.
That's what I know.
Jakari, you're here for theft. Allegedly, okay, State, I don't know. Let me ask this. Is this the city of Fort Lauderdale, correct?
Yes, Judge.
Okay.
Yes.
You want to resolve it? He's got a $500 bond today.
Judge, I have no priors on him.
Okay. Does he owe restitution, though we know?
No, he doesn't, Judge.
What did he take allegedly?
It was 4 packages of Black and Mild cigars with a total value of $19.04.
Okay, Mr.
Get up, sir.
Do you have a chance to speak with this young man?
I may consider jail today, Judge.
Okay, let me ask you something. You've been able to speak with the city attorney about this?
Yes, Your Honor.
Okay.
16
He has no priors.
0 1.
I could do one of two things. I could leave his bond the way it is, or I could let him resolve it today, plead no contest. I'd withhold adjudication, so he's not going to have any kind of conviction.
I think that would be in his best interest
So
if he
would you
wants to
like
get
to
out
plead
today.
no contest to this? If you do, I'll withhold adjudication, you're not convicted. Case will be over with today. Is that what you'd like to do?
Yes, sir.
All right. Mr. McLawrence, any reason you shouldn't take that plea today?
No, none that I can think of, Your Honor.
Sir, do you plead no contest?
Yes, sir.
I'm going to withhold adjudication. Thank you. Okay.
Judge, can we call Lawrence Fisher?
Lawrence Fisher. I think it's Hollywood,
No.
right?
Yes, Judge. I'm going to stand in for Hollywood on that one.
North Broward Unit, Your Honor.
Okay. North Broward. Okay. Open container, alcoholic beverage, open container, alcoholic beverage.
Oh, I know this guy. Yeah. Yeah.
Wow.
I'm sure he did.
What's the issue with this?
Judge, there's no issue. Obviously, just as a bit of a drinking in public issue. Judge, you want to resolve today's adjudication costs on each count, in each case? He has 3 cases, Your Honor.
Yeah,
Okay, let me see. Have you had a chance to speak with Mr. Shate?
No, Judge.
Mr. Shate, he's got a misdemeanor case also. The misdemeanor is the theft case, I believe, right?
He actually has 4 cases, Judge.
He's got 4 cases. Count 2's a misdemeanor. Here's what I do. The defendant wants to work out each case. What I'll do is he can plead no contest. I'll withhold adjudication on everything, including the misdemeanor, so they're all taken care of today. All right? I don't know. How do you feel about that, Mr. Shade?
That's fine, Judge. Sir, would you like, go ahead.
Sir, do you understand if you plead no contest, all your cases are over with today, including the misdemeanor? You're not going to have a trial. You're not going to have your day in court. They're all wrapped up right now. Do you understand?
Well, I do understand, sir, and I'd also like to say I'm trying to clean my act up so these things don't happen anymore.
Right.
I'm working part-time, and I'm tired of these kinds of things.
Right.
I know you're tired of seeing me, too, and I'm trying to get my act straightened out.
Have you thought about going to AA meetings?
Yes, I have started AA meetings.
Oh, good. How often do you go?
Maybe once or twice a week when I can.
Yeah, well, you're working part-time, right?
I am.
Well, you should probably be able to get over there every night of the week, right?
I can. I like their coffee.
Good idea. All right, you want to work these out today and plead no contest?
I certainly do, sir.
Okay, how do you plead to these 3 open container, 1 theft? How do you plead?
No contest.
Okay, sir, I'm going to accept that. I'm going to withhold adjudication on each and every count. Good luck. Thank you. I'm going to appoint Mr. Shate on 1, 3, and 4, all right? Thank you, Mr. Shate.
Thank you, Judge. Judge, did we have any rollovers from yesterday or this morning that we need to address?
Not right now.
I mean,
Yeah.
Where's Bruce Paul?
I'm at the coffee, Your Honor. Yeah.
Hi, Mr. Paul.
Take medication. Hello, sir.
How you feeling today?
Tired, sir.
Mr. Paul, you're charged with panhandling. Mr. Paul, how long have you been down here in South Florida?
I'm not sure.
Well, I mean, is it a week or a month or a year? How long do you think?
A week or a month, somewhere in there.
Where'd you come from?
I believe, I don't remember.
Well, how did you get here? Do you remember?
I took the bus.
And who paid for your ticket to come here? Do you know?
I did.
You did? Why'd you come to South Florida?
I came here to see my family, but they're not here.
Okay. All right. Have you ever been here before?
Yes. Not in this courtroom, no, but I've been in Florida, yes.
Good. Well, do you know where you are right now?
I'm in a courtroom.
Okay. And the courtroom is in which building? Do you know?
No, sir.
Do you know you're in jail right now?
Yes, sir.
You do?
I'm wearing a jail outfit.
Right. Hey, can I ask you, are you good in math?
I used to be, yes.
What is 3 plus 2?
That would be 5.
How many stars are on the United States flag? Do you know?
50?
Okay.
48?
Now, would you like to resolve your case today?
I don't have a place to go.
Well, I understand that, but I can't let you stay in the jail when we could get you out of the jail. You know, there's a homeless shelter right down the street from where you are. They'll actually give you a map when you leave jail and aim you in the right direction, all right? But we can't go on. You can't just stay in the jail, all right?
Yes.
So, would you like to plead no contest to panhandling?
What is that?
That means your case is over with. That means that it's resolved today. Would you like to do that?
I would need a place to stay, and I would do that.
No, sir. We're here in the judicial system. We're not going to give you a hotel or a dormitory. That's up to you. It's not. We're here to. This is criminal court, sir. Would you like to plead out today? Would you like to resolve your case so your case is over with today?
No, sir.
Okay. Well, on that note, I'm going to release you on your own recognizance. Thank you. You'll be released from jail shortly. I'm not going to let him stay in a dormitory, you know? So, Sean Falconer. Sir, open container of alcohol, Mr. Falconer. Yeah. Okay. So. Wait. Hold on one moment. I think we may have a couple on the second look. Falconer. This is Sean Falconer. And this is open container of alcohol. And it should be noted that Sean has drunk every contact I've had with him. Down on Fort Lauderdale Beach, allegedly drunk in the evening. All right, Sean, I know Sean's been in here quite a few times.
I've never been here but once.
Well, you've never been here but once.
Yeah.
All right, sir. You look that up. I got a feeling Sean Falconer's been in here more than once. And also, he's been known as Sean Falconer, Bond Falconer, Sean Falconer, Sean Cooper, Mike Bond, Sean Cooper, Michael Cooper,
Wait, what's his
Bond
piece?
Falconer, Sean Foster, Sean Paul Connor, and Null.
Wait, what's his piece?
That's when I was younger.
Okay, 847039. He says he's only been here one prior time.
Well,
Maybe twice.
Oh, okay.
no, it has been twice, but I mean, I don't understand why he has all those other aliases there. But.
Okay. So,
That's been from years ago. Yeah, I know when I was younger.
would you like to resolve your case today, sir?
Yes, sir.
Now, we have an attorney over here in the courtroom. Do you need any more time to speak with the attorney, or you want to plead no contest?
No, sir. No contest, sir.
Okay, the case will be over with today. You're not going to have a trial. We're not going to have your day in court. Do you understand?
I understand all that.
Now, Mr. McMorris, you've reviewed this. Is there any reason you think we can't go ahead and take a plea on this today?
No, Your Honor.
Okay, sir, you plead no contest, am I correct?
Yes, sir.
I'll accept that. I'll withhold adjudication. I need to sign an order for Mr. McMorris, okay?
Okay, thank you, sir.
Sir.
Is that it?
Outside, sir. Sir. No, thank What happened? I can't hear you.
The other attorney is here. Yeah, Patrice. Those beautiful Africans. You nearly did. You're telling me for it's in my mouth.
Your stomach.
Paul Neese?
Yes, sir.
Mr. Neese, you're here for municipal ordinance violation, sir.
Yes, sir.
So would you like to resolve it today, Mr. Neese?
Yes, sir. Yes, sir.
Okay. I think
No
you spoke to
contest.
Mr. Neese before.
I spoke with him yesterday, Judge, or the day
Did
before
I appoint
yesterday.
you yesterday or the day before?
I think you did, but I provided another order just in case, Your Honor.
Mr. Nace, would you like to resolve your case today? Plead no contest, case will be over with today.
Yes, sir.
Do you understand we're not gonna have a trial? We're not gonna, you're not gonna have your day in court?
Yes, sir. Yes, Your
I'll
Honor.
accept your plea of no contest. Well, let me ask you, do you need to speak with Mr. McLawrence any further about this?
No, sir. He's been very helpful. Thank you, sir.
Okay, thank you. I think we're gonna put a little star. You get paid double on that one, Mr. McLawrence. All right, thank you, sir.
Yes.
What? Yeah, always. Larry Vlado.
Good. All right. Thank you.
Yes, sir. Mr. Larry Vlado.
No, Diana. Hi, Your Honor. Could you see me?
Yeah, he sees you.
Okay.
Said hello, Judge.
He's on a...
Hold on, Vlado.
He resolved the day before.
Hold on. Okay, let me just see. What's your last name?
I don't know if there's an order finding incompetent, but we have one document.
I'm just saying.
Yeah, no, we'll take care of that right now. That's what's going on.
Not this one.
They call.
What was Vlado charged with? Do we know?
Who? Volado?
Misdemeanor.
Judge, the Office of the Public Defender notified me that Mr. Vlado was found incompetent to proceed by Judge Cohen in another matter.
I already, you know what I did? We sent this over to Judge,
Yes. Lerner read.
Yeah, but what am I charged for,
He
Your
opted
Honor?
out.
what?
Because
He
I
opted
had to go
out
on
of
June
Judge Lerner's
15th.
courtroom, and now he's in Judge Levy Cohen.
Right.
We have him on several cases.
And I told my judicial assistant yesterday to
Yeah.
send him over there, but
Yeah, but
she didn't do
the
it.
reason is I'm in jail for
Yeah,
two,
but
I'm in
he's
jail
just
for
gonna be
misdemeanor.
ping-ponged back because he doesn't want to participate. It's a
No, I
fine.
never said that. I want to go.
Sir,
I
I'm gonna
want to
have to
go.
cut you off for 1 minute, all right?
Judge, on the basis he's only been supervised, the city's gonna get rid of this one.
You do what?
I'm gonna no process.
Yeah, please.
I don't have no information, I don't even know if I no process it. First appearance, but
Yeah,
I'm
you
not
can
gonna
do
proceed on the case.
it. Noel Pross, court notes for the record, Noel Pross on Larry Vlado. Okay, Mr. Vlado, thank you very much, sir.
What happened?
They dropped your case.
Oh, I'm gonna leave today.
Well, I don't know about that, but they dropped this case, all right?
So they dropped this. They all honored me, right?
Yeah, basically.
Oh, so I'm leaving tonight, right?
Well, I don't know about that. I have no idea what other cases you have out there.
I have no other cases.
All right, good luck. All right, Andre Vegas.
Is that a Fort Lauderdale case as well, Judge?
He's just, yeah, he's in here quite often. Did I appoint you on this?
Hold on, Your Honor.
Always been coming in for 5 years. Does he? Is Andre Vegas over there?
Yes.
Paul Ryan, Your Honor.
All right, Mr. Vegas, how you doing?
All right.
Sir, I'm going to appoint Mr. McLawrence to represent you on your 2 cases. Send this to the division.
All right.
Thank you.
Well, I had one.
Judge, how do you spell his last name?
Vegas like Las Vegas, and the first name Andre,
Yes.
A-N-D-R-E. Thank you, sir. No.
My
He does have 2 cases.
Who's that, Palmy?
Here you go.
Andre Vegas.
Yeah, I got 1 ticket.
Yes, sir.
For what is it? For open? No. What is it?
Municipal ordinance violation, sir.
Trespassing. That's all.
That's why I appointed
Trespassing.
an attorney to represent you. The attorney's going
For
to help you through it, all right?
trespassing? All right.
Thank you. Miss
There's a Dennis Williams, Judge.
is there, hold on.
Bullshit.
Dennis Williams?
Yes.
I don't see him.
We gave him a withhold court cost.
Dennis Williams?
Yes, Judge. He may be on the second look docket, but
I don't, where's Dennis Williams? See, they get put on, but they don't make my docket, so I have no idea who this is. Dennis Williams. Just gonna have to reset it, all right?
I also have a note from BSO about a Seth Potter. They reset him. He had a misdemeanor that, and
I sent that to the division.
because they told me to place him on the second look docket. But you don't have it?
I don't have it, he's not on here.
Okay.
But I know Seth Potter very well, and I just sent him to the division, all right?
Okay.
Okay, thank you.
Thank you, Your Honor.
Judge, can I approach with Mr. Linder?
Excuse me?
Can I approach with Mr. Linder?
Sure.
Are we done?
Yes.
Let me find you.
Mr. Linder?
On some of these cases,
Okay, just give us a moment. Okay, now we have done with that whole,
I know, I was.
now, may I see Mayor Mashash? So you're charged with a domestic battery, which is probable cause. State, are there any priors on this gentleman?
He had a possession of cannabis in 2013.
Right now.
Tampering 2010.
Come on, I take you back. Hamper.
Now, okay, so Mr. Miller, anything you'd like to say?
Judge, Mr. Mashash is a 13-year resident of South Florida. He's been living at the same address the entire time. He works at USA Garage Doors as an installer. Has strong family ties, some money in the bank, no real estate or land. He does have a place to stay separate from the alleged victim while the case is pending, and he's hoping that his family will help to bond him out.
Let me ask, was there any contact with the alleged? No, sir. So I'm going to set your bond today at $2,500 based on the level of violence, your criminal record. Sir, the court will order that you have no contact directly or indirectly with Colette Burke. Do not call her, text her, email her, stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're out on release. Thank you, sir. You see Ivan Vedrine.
Main jail.
Sir, domestic battery by strangulation and license suspended on count 2. Court finds,
Any more for the voting or no?
I don't think so.
Okay, good. Thank you.
He's ordering them on all of them.
Anything on count, anything on this defendant?
Are there being no contact on that? No. Should. I don't know. One more. Hold on a second. Everyone's got to. I'm gonna start handing out numbers. Like a publish or something. Yes, Your Honor. Possession of marijuana last year, resisting without violence 2012. There might not be.
Okay, Mr. Miller, anything you'd like to say?
12-year resident of South Florida, has been at the same address for the past 5. He's got one child at home, a 6-month-old. Strong family ties, not currently working, has no money or real estate, does have a place to stay separate from the alleged victim, and he's hoping that his family will help to bond him out.
Okay, thank you. Was there any contact with the alleged victim? Yes. She has what? No concerns. So the court's going to set your bond on count 1. I'm going to set your bond on count 1 at $6,500 based on the level of violence. Court's concerned for the safety of the alleged victim. Count 2 is a warrant for $500. It's also based on your criminal record. Sir, the court will order you have no contact with Haley Garcia. Don't call her, text her, or email her. Stay 500 feet from her at all times. It's where she lives, works, goes to school. Anywhere in between, you're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you. Eric Fab.
Look, Mr. Fab speaks Creole, Judge. We need an interpreter, please.
Okay.
Tell him. Tell him what?
Give him another buzz.
Missy John Osis.
Yes, sir. Main jail.
Mr. Osis, you're wanted out of Georgia on a drug charge, and I will see you in extradition court probably on Thursday, all right, sir? Thank you.
Yes, sir. Is that it? That's it. Sure it was, huh? Yes, sir.
How about Sandra Dumerville?
President of Maine.
North Broad, Your Honor. North Broad, Your Honor.
Oh, you're not Sandra Dumerville? Sorry.
Hey.
Ms. Dumerville, you have a license suspended. That's a warrant for $1,500, ma'am. Thank you. How about LaShandra Seymour? Was it 150?
Main jail,
Billy,
decline
we set for the
PD.
afternoon?
Sorry.
Or was it for tomorrow?
They all take 9.
I'm coming.
Seymour, Grand theft auto, no driver's license, ma'am. Quick finds probable cause, Miss Seymour. And I have here she has no driver's license.
This is a vote.
State, any priors on her? Seymour, are you currently employed?
No, sir, I'm in school.
Where do you go to school?
Broward College.
Do you have any money in the bank?
No, sir.
Okay, who's gonna bond you out of jail today?
I would hope for my uncle, but I will hope for pretrial.
One moment, Your Honor. I've just got to check one thing.
I only have one prior.
Okay.
Well, I'm just.
Yeah, she said she only has one prior.
Aggravated battery.
But I guess what's a little confusing about that, Judge, I don't think she's given the right date of birth here.
Really?
Because
December 20th,
she said,
1995.
yeah, but the problem is that would make her 19. The aggravated battery she's referring to was under the name Tashea Wright, and that was a 2011 case, which means she would have been tried for an aggravated battery at the age of 16. It also shows her date of birth on that case was 11/28/92.
She gave another date of birth on that case?
I guess.
Of 1992. Interesting. Very interesting. And she's been known, her name is LaShondra Seymour, but she's been known as LaShondra.
That's what she was.
Tashea Wright.
That's what she had the ag bat under, that name.
Oh, okay, got it. All right, ma'am. I'm going to set your bond on count 1 at 1,000. Count 2, the court's going to set that bond at 1,000.
Yeah.
And it's based on your criminal record, the facts of the case. Your total bond's 2,000 today. Thank you.
Yeah, because I'm leaving. I don't want to.
May I see Frank Billy?
Billy, your attorney.
Mr. Billy? Sir,
Yes, sir.
we reached out to your attorney, tried to get a message to him. I don't think we were successful. So I'll give you a choice. We can wait till tomorrow and let you try to get a hold of Mr. Seligman and reset this case for tomorrow, or we can go ahead with the hearing right now. It's up to you.
I'll wait for my lawyer.
So I'm going to reset this for 1:30 tomorrow. Thank you. How about Tamise Taylor, Karma Taylor, Wavy Campbell.
Yeah, she's back. Yep, we checked. She's. Yes, ma'am.
Where is
Your Honor.
Yes.
Campbell is inappropriate.
Well,
Campbell's inappropriate. Okay, what about Karma? What about Karma Taylor?
Well,
do you have
this is gonna
Karma
keep happening.
in North?
We all have karma, Judge.
Excuse me?
We all have karma.
I lost that years ago.
I think Mr. Linder has instant karma, but we won't even have any John. Yeah, we want go back. Okay, so.
All right, I appreciate it.
You have no idea what I'm talking about. All
No.
right. All right, where's?
Is it that obvious?
Do we have Karma Taylor?
Yes.
Paul Ryan.
Okay. Hello, Miss Karma Taylor.
Hello.
What about, ma'am, you're charged with burglary of conveyance, petty theft, and windscreen violation, ma'am. It's alleged that you and I believe another woman broke out a window up in Pompano while it was parked at the beach. There were witnesses who said you then removed someone's purse, wallet, Apple iPad, valued about $250, and pulled over the vehicle you're in and Located inside the trunk was her iPad mini and under the passenger seat where she was sitting. So her purse was in the trunk, her iPad was under your seat. State, do you have any priors on her?
One moment, Your Honor.
Ms. Taylor, are you currently employed?
Yes,
What type of work do you do, ma'am?
I'm a licensed health insurance agent.
Okay, do you have any money in the bank?
Yes,
How much do you think you have, ma'am?
I'm not sure.
Okay, go ahead, State.
Okay. No priors, Judge.
No? Ma'am, I'm going to go ahead and I'm going to, based on the amount you allegedly took, the strength of the case against you, I'm going to set count 1 at $3,500, ma'am. Count 2, the theft, $500, and your total bond's $4,000. You can bond out of jail, ma'am. Thank you. How about Wavy Campbell? Oh, Wavy's...
Well, Your Honor,
yeah.
Here's the thing, and it's not a medical reason at this point. I really do believe this is something that could continue day after day after day without having a first appearance. I mean...
Judge, I don't object to the court finding probable cause. There may be some mental health issues there. She was on loan before. She's inappropriate now. I just asked the court to give it another day.
But then, you know, you give it another day and then another day.
Well, I'm asking for 1 day. I mean,
Well, this will be the 3rd day now.
no, this will be the 2nd day.
She got arrested. She came up Monday, didn't she?
Monday, so the 2nd until 3rd day would be Wednesday.
But she's also been in since Saturday night, or she was never on loan. It was just.
But she was on
no,
loan.
No, it was just a med reset. But she's been in since Saturday night.
I'm gonna go ahead and just take care of it now. Are you seeking a foreclosed bond and release conditions?
Yes, Judge.
This is burglary with the battery. Do you have any comment, Mr.? During a party, Wavy Campbell entered the residence via unlocked front door and battered Felix.
Judge, my only thing is, it seems that just my reading of the probable cause affidavit, there was a party there at the time. Who they may have known each other before. I mean, those are my only things I would just point out from my memory of the probable cause affidavit.
Felix believes she may have met Campbell before via a non-profit organization she runs. However, she has no current stated relationship with Campbell. Campbell also has no permission to enter or remain at her residence. It says, okay, I'm going to go ahead and I'm going to find proof evident presumption great today based on these facts contained in the affidavit. Evidence.
Asking with the court, it's been brought to my attention that there are some mental health issues, and that would the court consider appointing the public defender's office and order a mental health screen?
Well, I'll order a mental health screen. I'll appoint the public defender.
What? So in the morning, Jill brought it up to me. I can't give this to you. Get this one that helps you needs. I want you to read this this evening. This is from about Leo, that file on President. It gives you a little bit of insight.
I'm gonna make sure you get back.
How you doing,
I
Mr.
just wanted
Brutus?
to let you see that. I just wanted you to see that. And also, she was big racked on this one, and here also.
Okay, may I see Eric Fab?
Eric Fab. Where all my concern comes from. The last time she came through.
How you doing, sir? Are you waiting for a case?
Doesn't sound like it. It was a trespass in someone's home.
What's your name? Okay, Mr. Murphy, nice to meet you. Are you in school right now? Oh, great. That's where I went. Where's Eric Fab?
There's no doubt about it.
Eric Fab. Do we have Eric Fab?
I just wanted you to see that. Yeah.
Mr. Brutus, do you swear or affirm to translate from English to Creole, Creole to English truthfully? To the
I
best
do.
of your ability.
I do.
Okay, where's Eric Fab?
Côté Eric Fab.
Main chair.
Hey, good afternoon, Mr. Fab.
Monsieur Fab, bonsoir.
Sir, you are charged with multiple serious counts.
Monsieur Fab, yo chargé ou de plusieurs chefs d'accusation qui très sérieux.
Aggravated assault on a police officer, 2 counts.
On fait agression sur un officier de police, il y a charge deux d'accusations sur vous.
Battery on a police officer.
Et puis ensuite, ou voltier sur police tout.
Count 4, aggravated battery with a deadly weapon.
Et quatrième, c'est que vous utilisez une arme fatale pour foncer sur police là.
And resisting the police with violence.
Et puis ensuite, d'après résister avec violence contre service police là.
The court finds probable cause.
Il y a une raison valable.
See, do we,
I don't have anything prior. Patrice, did you have any notes? Do you have any? That's what I thought. Thank you.
sir, are you currently employed?
Est-ce que vous travaillez pour aller là, M. Fab?
Do you have a job?
Est-ce que vous avez un job pour travail? I think you can't hear us, son.
Can you hear us?
We can hear fine.
Okay.
Mr. Fab, how long have you lived in South Florida?
Combien de temps depuis vous habitez en Floride?
Do you have money in the bank?
Vous avez l'argent à la banque?
Judge, Mr. Fab does not seem to be responding to any of the court's questions. At this time, I would ask the court to end this hearing and have him examined by a physician before we go any further.
Okay, that will be denied. The court can set a bond and set release conditions independent of whether or not he decides or chooses to answer the court's questions. But
Judge, we don't know if he's able to understand the court's questions.
Yes, sir.
Or if he's able to respond to the court's questions. Going forward without that knowledge, I think the court doesn't have enough information to make that decision.
Yes, sir. The court will set the defendant's bonds as follows, based on the level of violence the court's concerned for the safety of the safety of the people involved. I'm going to set count 1 at 1,000, 2 at 1,000. Count 3, battery on a police officer. Court's going to set that bond at $2,500. Aggravated battery with the deadly weapon. The court will set that bond at $5,000. Resisting arrest without violence at $2,500. So his total bond will be $12,000 today.
Could the court at least, in the abundance of caution, just order a mental health screen?
I'll
Just
order a
based-
mental health screen.
And a medical screen? I
Ménage
don't
une
know
raison
his
et que
condition.
tout chef d'accusation ça yo et qui totalisé une amende de $12,000 pour ta capable sortir c'est décision ça que le tribunal a prendre aujourd'hui là.
Mr. Fab,
Monsieur Fab,
how are you feeling today?
qui j'en est aujourd'hui là?
Would you like to answer some questions?
Est-ce que tu as aimé répondre à 2-3 questions?
Sir, if you want to talk to me, will you just raise your hand?
Monsieur, si vous voulez parler, levez-moi en l'air.
Okay, you know what? I'll let him have a. Would you like me to order a mental health screen for him, and then, you know, if you find something else out, I mean, you know, if he doesn't want to talk, whether it's mental health or whether it's obstinance, either way, I have to proceed. I mean, one way or the other, I have to set some bond and release conditions, determine probable cause. So, you know, I'll do it without prejudice if you want to come back in the next couple days and tell me something else. But I'm going to order a mental health screen for this gentleman. Thank you.
And in an abundance of caution, Judge, I'm not sure if we have this guy or not. Can we get an order appointing the public defender's office,
I'll do
please?
that. I'll do that.
Thank you.
Okay, now, you want to make an announcement?
Est-ce qu'il y a un détenu là, haïtien qui parle créole? Est-ce qu'il y a un détenu dans cette salle là, haïtien qui parle créole, qui a besoin de service interprète?
And no takers at the main.
It's not even showing you the misdemeanor that we, you know, no info, down file.
That's it.
Wait, hold on, hold on. Wait, hold on.
Merci.
Hold on.
Miguel Galvez, Ricky Williams, Ernest Davis.
Judge, Mr. Galvez would like to resolve this case if possible.
See, I don't understand this.
Sir, loitering or prowling?
This doesn't make any sense whatsoever. I'm looking at 158683 CF10A. Hold on. Yeah, what I put in 156185 in charges, I get
Observed knocking on her front
158683.
door, pulling on the doorknob of her
Which shows an
residence and looking
information
into the
file.
windows. She said she was scared. The fact is she did not know him.
Okay, you know what? It's fine. We'll take care of it.
She was visibly shaken. Another witness observed Mr. Galvez knocking on the window of a white Lexus in the driveway and looking into it. This was in the evening, late in the evening. All right. Say, do you have any priors on Mr. Galvez?
One moment, Your Honor. Could you run the priors for me, please? Well, you can even go in safes. I'll give you the paperwork.
Not that, I'm looking at my SCIC.
Disorderly intoxication, resisting without violence, 09. Disorderly conduct, 05.
Sir, would you like to resolve your case, Mr. Galvez?
Please.
Would you like to plead no contest or guilty?
I don't know what the charges you want. I have.
You're charged with loitering or prowling, peeking in people's windows. Would you like to...
I work in that place.
Would you like to plead
Everybody knows me. Everybody knows me there.
Except the lady who said you were peeking in her window. She had no idea who you were. Would you like to plead no contest? Get the case over with.
Okay.
You want to plead guilty or no contest?
Yes, sir.
Sir, do you understand
Nope.
that the case is over with today? There'll be no trial. It's wrapped up right now. Do you understand that?
Case is over. This is the end of it. This is your day in court.
Okay.
Okay?
How do you plead, sir?
No contact.
Okay, I'll accept that. I'll withhold adjudication. Thank you.
Thank you,
How
Judge.
about,
Down the middle.
Ricky
George, good luck.
Williams? Oh, Ricky.
President Domain?
Okay. Ricky Williams, license suspended, count 3, no bond. You got picked up on another license suspended on count 1. Bond is 100. Thank you. Now see Ernest Davis, Dwight DeVoe, and here's Andre Vegas. That was one sign. Okay, Ernest Davis, license suspended, $500 warrant, sir. Thank you. How about Dwight DeVoe? Do you see? Can you turn on
Right here.
around for this gentleman, Mr. Murphy?
Judge, Mr.
That's
DeVoe
what I
is
see right
present
there.
at the main
Yes.
and does not want the public defender.
No. Mr. DeVoe, would you like to get out of jail today?
Yes.
Well, you're charged with possessing paraphernalia. Would you like to plead guilty or no contest to this charge and it'll be over with today?
I pleaded not guilty when he arrested me, and I went to court the last time.
Well, would you you want to get it over with today and just plead no contest and that'll be the end of it?
Yes, sir.
You understand if you plead no contest, you don't have to come back to court. It's over with right now, right?
Yes, sir.
Okay. I'll accept your plea. I'll withhold adjudication. Take care, Mr. DeVoe.
You do the same.
Thank you.
Thank you.
Sir. Okay, how about Dondre Nelson? DeAndre Nelson?
No problem.
Nelson, are you here?
Mr. Nelson, Dondre Nelson.
Right here.
So
How you
have
doing,
a petty theft warrant 250, resisting arrest, ROR, violation of probation, grand theft, no bond. Grand theft warrant, no bond. Thank you.
Mental health screen, Judge, just based on what his attire. Just bring it, Susan.
Okay. Odlin Arbin, Jeffrey Hayes, and Kenny Huff. Odlin Arbin.
Main jail.
Possession of cocaine, license suspended. Court finds probable cause. Do we have any priors on this gentleman?
Trace, do you have anything? For this.
Got it. Anything else? Got it. Okay. Mr. Odlin Arbin, sir, do you have a local address? I have, you don't have an address on this document. Do you have a local address?
He does, Judge.
What is that address?
3121 Northwest 19th Street, apartment 104.
I'm going to do PTR pending, all right?
He's
What?
Your Honor, he's
Hold on.
he's out on a possession of cocaine.
Oh, okay, what's the case number?
1414937 CF10A.
Sir, today I'm going to set your bond at $1,000, revoke your bond on 1414937 CF10.
Sorry.
You're going to be held without bond. Thank you.
Good luck.
How about Jeffrey Hayes? Jeffrey Hayes.
Medical reset, Judge.
One of your guys keep send an email up in just a minute.
Also?
But
So
I just
Wednesday
wanna give you
PM.
the emergency notice.
Who, Jeffrey Hayes? I'll do it
Wells
one more
Morgan,
time.
who's one of John Goodman's cases.
How about
This is gonna be-
Kenny Huff?
Medical reset.
Okay, I'll do it one more time. I'm going to set it for Wednesday PM.
Yeah, this one guy, I guess, was up for rain today, so literally just set the bonds back to where they were originally.
Alonzo?
Your Honor, you taking Rowry's?
That guy we had charge of.
Excuse me?
So you just get that.
You taking Rowry's hold, Your Honor? Hold. Can Rowry's hold?
I can't understand you, sir.
Hold. What's his last name?
Canaris Hall.
There's multiple.
Canaris Hall, Judge, is on page 20 of your docket. There's no paperwork, so you may not have any information on it.
They're asking about the top, not Hall, whatever.
They're asking about Hall. That's what I'm telling you, Judge.
They're walking, so he thought they were talking about the other page.
I don't have any
Got it.
paperwork for it. I don't have any paperwork on a hall.
No?
No, reset it, thank you. Alonzo Costello.
Main jail.
Costello DUI. Second offense, unlawful speed. Probation violation on count 4. And that's for reckless driving in another state. Let me just look here. A DUI in 2000. So I'm going to set your bond at 1,000 on 1, no bond on count 4. Thank you. Sean Pascal.
Main
How you
jail.
doing, sir?
Sir, possession with intent to sell, manufacture, deliver cocaine. Count 2, resisting arrest without violence. 3, loitering and prowling. 4, tampering with evidence.
Page 21.
Offense probable cause state. Do we have any priors on this gentleman?
Patrice, do you have anything? Did I give you that? My bad.
Got it. Huh?
Sir, do you have any money in the bank? Jeez.
No, sir.
Are you currently employed?
I go to the labor pool every morning, whatever they can do at the labor pool for me.
Right.
I have 3 kids, though. Child support last month.
Okay.
Yeah.
So we're gonna have 2 prior cocaines, 2 marijuanas, a couple distributing cocaine. I'm gonna go ahead and set your bond on count 1 at $2,500. I'm going to release you ROR on 2 and 3. Count 4 is going to be $1,000. Total bond's $3,500, sir. Thank you.
Thank you.
Good luck.
Thank you.
Bert,
Do we have Matthew Burke?
main jail?
Yes, sir.
So we reset this case.
Your Honor? Yeah, I provided a supplement. And I provided a copy to the defense. Officer Fairburn lists what his training was. He attended a class on spice approximately 2 years ago hosted by BSO. But addition and notes that Mr. Burke made statements that he got the spice he ordered from California because the stores here won't sell it.
Well, Judge, I think the ultimate issue is the field test, no matter his training or experience. I mean, even though defendant, that's what they do. They field test the drugs, and you know.
And Officer Fairburn informed me it cannot be field tested, but obviously there's no requirement that it has to be field tested because then you couldn't arrest for pills because pills can't be field tested. If someone makes an admission, clearly an officer it gives the officer probable cause to make an arrest.
Right. Okay. Really good.
And actually, Your Honor, for spice, which is like marijuana or cannabis, my understanding is that there is no test done at trial to admit in evidence. A chemist comes in and says they observed it under a microscope, describes it and identifies it. So clearly, even at a trial posture, testing doesn't have to be done on every substance.
All right. The court's going to find probable cause based on the supplemental report. In facts of the case, excuse me, totality of circumstance. Mr. Miller, anything you want to say? This defendant has, looks like he's from Santa Monica, California.
Well, Judge, I don't know that we have actually, I know you found probable cause, but I don't know that we have established that spice, whatever that is illegal. I don't know how we know it's even a controlled substance. We don't know what that substance was that he had. We don't know that it's actually controlled. We don't know. I mean, you're finding probable cause based on nothing, Judge.
Yes, sir.
So I don't,
well,
I
the court
don't know
disagrees. The court is
his
finding
I have
probable
no
cause
objection
on
to the
something,
court finding
sir.
out.
But thank you very much for that comment. I appreciate it. We're gonna, what I tell you. All right.
Judge, I have no objection to the court inquiring of Mr. Burke, his ties to the community.
Okay. Mr. Burke, how long have you been in South Florida?
I just got in South Florida on the 4th with intentions to move into an apartment the end of next month because I am my own payee now of my SSI benefits.
Where'd you come from?
I came from Santa Monica.
How did you get here?
On the plane.
And you, okay, you flew from Santa Monica to Fort Lauderdale?
Yes, with those contents in my package.
Let me ask you, why did you come to Fort Lauderdale on an airplane?
To move here because Santa Monica is kind of having a police problem. And I was born out in Florida.
But why, my point is, why Fort Lauderdale? Why not Orlando? Why not Tampa? Why not
it's
Jackson?
lovely.
What?
It's lovely. I've been here. I've been here a few times. I
Oh,
very
okay.
rarely have any problems
I understand.
with the people or the police department. You guys are very fair out here.
Oh, thank you.
Other than that, it's just a wonderful location.
Thank you. All right, Mr. Matthew Burke, do you have any money in the bank right now?
I don't. I do not.
Where are you going to be staying while you're here, sir?
At a hotel down the street from Beach Place Plaza.
Do you have an apartment or?
No, it's a hotel. It's $62 a night. So if I go work labor ready, I can get the money to get a hotel every night.
Is it possible
Until
you
my
get on PTR pending? What? No?
No, because we consider it exercise.
So I'm gonna reduce your bond to $100. All right, thank you.
All right. Good job. Good luck.
Case.
Okay. I see.
Yeah, I know, but don't they have to know info the misdemeanor case number?
Paul Ryan, who do you have up there? We're going to start at Paul Ryan today and work our way. Put around the horn. Paul
See,
Ryan, who
first
do you
of all,
have up there?
See, here's the thing.
What do you need?
Absolutely no sense.
Eileen,
whatsoever.
I'll be
I
out
didn't
here.
because I mean, yeah. So was it merged? Because he was at charge with strangulation. It's not just an up-file strangulation. Well, here's the problem. The clerk's office needs to clear this up on their screen because it's not. The misdemeanor needs to be cleared up because there needs to be it needs to show that there's a connection between the felony case and the misdemeanor case. And it's not showing any connection. Well, if you could get someone on the phone, we don't have time for them to wait for that.
Miss Alboyajian. Is this a Sentinel mistake?
Let me see. No, no, this is a 30-day, Judge.
30-day?
Yeah, she's eligible for release.
Okay, Miss Alboyajian.
Yes.
I'm gonna order you released on your own recognizance today, ma'am. Thank you.
Thank you. Lindsay just got.
Okay. What's your name, ma'am?
Lindsay just got.
Okay, ma'am. Hold on one moment. Scott. Tell me what's going on with trespassing. Ma'am, how come you haven't bonded out of jail? Ma'am, do you have any other cases?
Sir?
Go ahead. Ma'am, Ms.
No.
Scott, do you have any
Sir?
other cases besides the trespassing case?
No, sir.
Well, it's only $25. How come you're still in jail?
Cause they raised the judge had raised it to $100.
$100?
Yeah, but why?
Yeah.
And you can't, no one in your family can afford to get you out of jail?
Mm-hmm.
I don't really know nobody's number.
Right.
The judge took police on every other one person.
Right.
She was kind of like she didn't know what was going on.
Oh, really?
Yeah. And he had her to sit down, listen to everyone's plea. She came back and she's still like, what do you mean? You know, so there's no.
Oh, okay.
Is that
Would you like to resolve your trespassing case today and plead no contest? Or I can just leave your bond at $100 and you go see your trial judge and maybe in a week or two and you can work it out there. What would you like to do?
Repeat, sir.
Ma'am, would you like to plead no contest today? Your case would be over with today. You don't have
Yes,
to come
sir.
back to court. Or you could not do anything and just I'll let the matter stay the way it is and you'll see your judge in a couple of weeks. What would you like to do?
Complete my case today.
Okay, how do you plead to trespassing, ma'am? Plead no contest?
Yes, sir.
Do you understand we're not going to have a trial? The case will be over with today?
Yes, sir.
Okay, I'll accept your plea. I'll withhold adjudication. Good luck, ma'am. Thank you.
Next person. What your name? He said.
Okay, what's your name, ma'am?
Nikki Pellicer.
Page 3 on the misdemeanors. Trespass on school grounds.
Close here, okay, page 3. Okay, Ms. Pellicer. Trespassing, would you like to resolve your case today, ma'am?
I don't mind.
What?
Well, if you plead no contest, your case will be over with today. That's the end of it. You're done. That's it. Would you like to do that?
So that means I'll be released today?
Yes, ma'am.
Okay.
So if you plead no contest, case is over. You're not going to have a trial. It's resolved right now. Is that what you want to do?
Sure.
How do you plead, ma'am?
Yes. No contest.
I'll withhold adjudication. Thank you. Okay. Who else is up there? What's your name, ma'am?
Alicia Cheney.
Name was Cheney. Criminal mischief, ma'am. Give me a quick moment. How come you're still in jail? How come you haven't bonded out of the jail now?
I don't have the money.
Okay, are you from down here in South Florida?
Am I from South Florida?
Well, I mean, have you lived here for a while?
Detroit, Michigan.
I plan on being here for like another week.
Oh, okay, you're from Detroit, Michigan, right?
Yeah.
I remember this. You came down, I think are you a nurse?
It took a little bit.
Huh?
Are you a nurse or you're in technical?
No, I'm not a nurse.
But you're down here on business, right?
No, vacation.
What do you do for work, man?
I don't work. Somebody help me out. Somebody's helping me out.
Okay. Well, how come your person who's helping you out hasn't bought you out of the jail yet?
I don't know the number by heart.
Would you like me to? Oh, okay. Are they local here in town?
Yeah.
Well, they haven't seen you now in 3 or 4 days, right?
Yeah.
Do you think? I wonder if they would have thought to look in the jail and, you know.
Well, I don't usually go to jail, so I don't know.
No. My point is, I've said this many times, that if my wife went missing for 3 or 4 days, or one of my best friends I see all the time, I would probably call the hospital.
Well, I don't see them all the time.
I call the police. I call the morgue, and then I probably
first
call
of
the
all,
jail. I'm not sure in that order.
She vacationed by herself in South Florida? This is a Blue Martini. She
Yeah.
had a Blue Martini alone?
Yeah.
That's a little weird to me.
All right, ma'am. Here's what I'm going to do. I'm going to release you on your own recognizance, but you're going to have to come back to court. If you don't come back to court, there'll be a warrant put out for your arrest, and the next time you try to get on an airplane at the airport or whatever, they'll pull the warrant up, you'll get arrested, and you get brought back from wherever you are back to this jail. So you want
When's my court date?
Well, I'm not sure about that right now. Hold on.
Yeah, come
Cheney,
back down
Alicia
here.
Cheney.
Alicia.
Sorry about that, man. I meant. How do I get that wrong? So your mail's going to go to Oakland Boulevard in Detroit, Michigan, all right?
My mail?
Yeah, that's your
No.
address, right?
Oh, my address for Detroit. I don't live there anymore.
Do you know anyone who still lives there?
No. Well, you can send it there, but I can go see if I can go pick it up.
Ma'am, it may be up to you to go to the clerk's office or call them here in Broward County when you're released from jail, and let them know where your address is going to be. All right?
Okay.
Thank you, ma'am.
Yeah.
Okay. Anyone else? How about let's go over to let's slide south and go to Conti now. Conti facility. Who do you have?
Yes, Your Honor, we have a few people.
Who do you have?
We have Sanchez, G.
Your Honor?
Sanchez, okay.
Yes, sir.
Hey, sir, what do you want to do here, Mr. Linder?
Who is it?
Sanchez.
Oh,
James.
this is a second one.
Okay.
It's a felony criminal mischief.
You guys
He was medically reset for like 3 or 4 days.
Yeah, he was.
He was with the court. Do you have a stable address, or what's your address?
It's 729 Northwest 7th Street.
Can you? Who lives there with you?
My cousin Ricardo, he's letting me stay there. Ricardo Vega. The address was verified.
You did an order to put him in SAP.
Just with the court pretrial release, ROR.
Yeah, it's a Flocka case, and
Oh, it is. I remember this. He fell through the ceiling at Publix, right?
Yeah, but
He fell.
Dollar General.
Don't talk about your case.
It was the
because
Family Dollar.
What you say,
Yeah,
they're
he
going to
entered
use
through the
against you.
public
So just,
bathroom, then fell through the employee-only bathroom. And yeah.
He was climbing over the walls.
He pushed a refrigerator down a refrigerator, barricaded himself inside the break room, saying about $5,000 worth of damage. He yeah, but I agree with you 100%. The only problem, my concern is if he's doing Flocka, I don't think see him as being hireable.
I'm just saying, it looks like
Sir, it's my first time.
No. No, that's yeah. Well, Your Honor, my concern is now he just said it was his first time. Right in the report, he stated that for approximately the last 2 months, he has become addicted to Flocka and has been ingesting it every day. So,
I think he meant that was the first time he fell through the ceiling of a bathroom at a Dollar General.
I might.
I'm just saying that we're talking about, I think, regular convenience.
Sure. Sure. You think that
It wasn't mine.
Flocka's gonna just...
Well, he's not on Flocka now.
That's my concern, is that if he was in fact saying that this is the first time, then he might be trying to say anything that'll get him out at this point. I don't know, that's my concern. Well, apparently this person, whenever...
Wait, stop. Would you take him, Patrice? I'm gonna send him to pretrial release. You have to report your pretrial release tomorrow between 8 and noon time, sir. You're gonna be drug tested every week. If I find out you've gone back on Flocka or any other drug, you'll be rearrested and put back into custody. Do you understand that?
Yes, sir, I understand that.
Report tomorrow, downtown Fort Lauderdale, between 8 and noon. They give you a map right there. Thank you.
Thank you, sir.
Okay.
You got me there.
What's your name, sir?
Kendall Tuff.
Kendall Tuff, okay.
Kendall Tuff, yeah.
You probably move you somewhere because you try. Okay. No. When you leave it. What you do?
Sir, you're here for loitering and prowling. Would you like to
Yes,
resolve
sir.
your case today, sir?
Yes, sir.
Okay, just give me a quick moment. Sir, would you, how do you plead to this charge of loitering and prowling?
Excuse me, sir?
You understand we're not going to have a trial, the case is over with today?
You have two options. You can either plead not guilty, say I'm not guilty to the offense. You're entitled to an attorney investigating your case. If you want to resolve your case, then you can plead no contest or guilty. No contest means that you're not admitting or denying anything. You're just informing the court that you don't wish to go to trial. You just want to get this over with.
Yes, I would like the no content.
Okay, I'll withhold adjudication. Thank you, sir.
You're welcome, sir.
Who else do you have at Conti?
Mayo.
Your Honor, it's a 30-day. I'm going to ask it to be reset for tomorrow. That'll be the 33rd day.
Okay, I'll do that. I'll reset for Mayo, brought you in a day early. Reset you for tomorrow, okay?
Can we RR him now?
Thank you.
Can we RR him now?
Okay, what about anybody else at Conti? There you go.
Yes.
What's your name, sir?
Demuspen Benade.
This is also a 30-day. This is the 32nd day. I'm asking that to be reset. Demos theme.
Okay, we'll see you tomorrow, sir. We brought you in too early. We'll see you back tomorrow.
Thank you.
Okay, who else do you have? What's your name, sir?
Kevin Riley, Your Honor.
Hey, Mr. Riley. Mr. Riley. DUI third. How come nobody in your family's come to bond you out, Mr. Riley?
I haven't been able to contact him yet, Your Honor.
Well, you live with them, right?
Yes, sir.
Don't you think they know you're in jail?
I have to get to my personal effects and.
No, but what I'm saying is, don't you think your family already knows you're in jail?
I figured my sister would have got a hold of me by now, but.
Judge, with the court signed an order to allow him access to his property, Do you have your phone in there? Do you contacts in
yes,
there?
Yes, I do, sir.
Okay, so what I'm gonna do is I'm going to assign an order so you can go look at your phone to call people, all right?
Yes, sir.
Okay, thank you.
Thank you, Your Honor.
Okay, who's next at Conti?
That's all, Your Honor. That's it for country.
Let's go to North Broward.
Metzler.
Metzler, you're here for theft. Looking here.
What you say, Your Honor?
You're here for theft. Stealing.
Petty theft? You said petty theft, sir?
Yes, sir. Okay, sir, would you like to resolve your case today?
Yes, sir.
Okay, and you're charged with petty theft, and I'll plead out your case today. The case is over with, and you do not, you're not gonna have your day in court. It's wrapped up right now. Do you understand that?
Yes, sir.
Sir, how do you plead?
No contest, sir.
Okay, I'll accept that on withhold adjudication, Mr. Metzler. Thank you.
So I will be released today, sir?
Yes, sir.
Yeah, thank you, sir.
Yes, sir.
Tell your name. Jonathan. Jonathan Brooks.
Okay, hold on, sir. Okay, Mr. Brooks, so you're charged with trespassing. So would you like to
Yes,
resolve
sir.
your case today?
Yes, sir.
How do you plead to trespassing?
Sir, you actually have two options. You could plead not guilty, have an attorney appointed, or retain your own attorney and fight this case. The state has to prove the charges beyond a reasonable doubt. Now, you have every right to do that. If you want to resolve this case and get it over with, you can plead no contest or guilty. No contest means no contest means I'm not admitting or denying anything, but I want to get this over with. It's my best interest to finish this case.
Okay.
So the judge is asking you if you want to resolve it today. It's your choice.
Yes, sir. Yes, sir. No contact.
Okay, I'll accept that, sir. I'll withhold adjudication. Thank you.
I'll be released today, Honor.
Yes, sir. Okay, who's next up in North Broward?
That's it, Your Honor, for North Broward.
Thank you. We're gonna take about a 1-minute break. I want to stretch it real quick. Here we go. We're back at Maine. Best for last, they say. Here we go.
Yeah.
Okay, who do we have at Maine jail?
I think that's Vegas.
Judge, this is Fontana Ayala. Jose Fontana Ayala. He's here on a trespass since been here since July 3rd.
Okay, sir, would you like to plead no contest or guilty today, Mr.
Yeah.
Fondes?
Yes, sir.
Your Honor, just out of curiosity, where was he
No
trespassing?
contact, yes, sir.
I have a reason for asking.
Fondes Ayala has been in here many, many times in the past.
Yeah, it's normally, it's normal. It's normally for taking things that don't belong to him, but I'm just curious if he was at one of the numerous businesses that he frequents.
Chevron gas station.
Okay, that's fine, Judge. If your court's inclined to resolve it, I have no objection.
He goes up to people, asks them for money. He's always trying to get free alcohol. Okay. Mr. Fondes Ayala, would you like to plead no contest?
Yes, sir.
You understand we're not going to have a trial. The case is over with today.
Yes, sir.
All right, sir. How do you plead?
No context.
Yeah, I'll withhold adjudication. Good luck, sir. Don't go back to that.
Thank you, sir.
Don't go back
Yeah,
to that
thank you very
Chevron
much.
gas station, sir.
Thank you. Okay, thank you.
Yost? Stephen Yost, Judge. He's on a DUI.
Where were you arrested?
Yes. But it was dropped.
DUI, refusal to submit, open container. Okay, Yost, give me a moment.
The DUI was dropped. The possession of oxycodone and morphine was not.
It was. It was dropped. It was dropped.
Yost, how long have you been in jail?
All right.
How long have you been in jail?
No, Patrice.
This week?
Patrice.
Altogether. What day? A week altogether, Judge.
Yost,
Yeah.
how come you haven't bonded out of the jail yet?
I haven't been able to contact the person to bond me out,
Yeah.
but I had a prescription for
Don't talk
sir,
anymore about your
sir,
case.
sir. I asked
Don't
you a
talk anymore
question. How
about
come you
your
haven't
case.
bonded out yet? That's all. What?
Okay.
What? Is
Haven't been able.
Is your person local here in town?
305 area code, Judge.
Tell me the number. Who is it?
305
Okay, hold on. Go ahead.
592
Okay.
3860. It's Manny.
Who is that?
Manny.
Manny. Okay.
He needs to reach Robin.
Manny needs to call Robin and let him know Mr. Yost is in custody.
Okay. Please call who? Robin.
I don't think anyone's calling anyone. Or at least anyone's telling anyone anything. I don't think anyone's picking up.
How about Robin's number?
954.
There you go. Hold on. Go ahead.
954 275 7534. Not my cell phone.
That didn't work. All right.
What? I don't remember.
Judge, would the court consider signing an order allowing Mr. Yost access to his
I will.
cell phone?
I'll do that. Give me an order. I'll sign that so I can see his cell phone. Thank you, Mr. Yost. Is that it?
at the main.
That's it. That's a wrap. Thank you.
Well,
And
these
see
city
everyone tomorrow.
cases, but you're not going to confuse the
We're out
city
from
case with
2:35.